लर्नड काउंसिल यहाँ लर्नड काउंसिल
की एंट्री भी है,
आप आइटम 58 देखेंगे
जी,
आइटम 58 और दूसरा मुझे सिर्फ ये बता दीजिएगा
Part 2 entry 3 तो देखें,
notwithstanding आर्टिकल 191 आपका आर्ग्यूमेंट ये है कि the parliament is bereft of jurisdiction to legislate in the context of any of the fundamental rights or access to justice.
My lord, I have not articulated my argument as yet.
अगर आप ये
मैं
अगर आप कर ले, आई थिंक बेहतर होगा अगर आप
argue as you want.
Please go back to your.
I apologize. You argue as you
Your
want.
lordship should not apologize.
चले करिए.
My lord, for 2 days I have heard all our questions.
करिए.
Let me address those questions.
करिए.
This is what I'm saying. Yes. My lord, I will answer your lordship's question also.
अब आप
Let
कर
me
लीजिए ना.
formulate.
हाँ.
My lord, the starting for legislative competence is entry Article 142 or the body of the Constitution. Now, body of the Constitution for our present purposes, the only article relevant is Article 191. In the legislative list, there is entry 55. Now, these are the two provisions that have to be interpreted and read. Article, as I read, Article 175(2), the expression subject to law, which is used in 191, is used in various other articles also. That by itself does not confer any legislative power or on any identified legislature. Just kindly look at Article 14. Article 14. 1-4.
man.
Dignity of man.
Article 14
It says, the dignity of man and subject to law, the privacy of whom shall be inviolable. This by itself doesn't say who will make the law. The province will make the law or the federation will make the law. In order to determine who can make the law for the purposes of Article 14, you have to go to other provisions of the Constitution. The same is with respect my submission for Article 191 also.
ये आर्ग्यूमेंट आप पूरा तो कर लें तो प्राइवेसी के मुतालिक कौन बना सकता है कानून?
मतलब फेडरेशन भी बना सकती है और प्रोविंस भी बना सकता है, दोनों बना सकते हैं. उनके लिए आपको देखना पड़ेगा कि लेजिस्लेटिव पावर स्प्रेड कैसे है, और दोनों ने बनाए हुए हैं, क्योंकि क्रिमिनल लॉ, पीनल लॉ पे
हो सकता है गलत बनाए हों,
प्रोविंस भी बना सकता है. और प्राइवेसी वगैरह के बारे में फॉर एग्जांपल इलेक्ट्रॉनिक क्राइम्स एक्ट है, फेडरेशन ने भी बनाया हुआ है.
नहीं, पर उसी तरह अगर चलें तो 191 में सब्जेक्ट टू लॉ है, एंड सपोज देयर इज नो, एंड आई थिंक देयर इजंट एनी कॉरेस्पॉन्डिंग एंट्री रिलेटिंग टू प्रैक्टिस एंड प्रोसीजर.
देयर इज नो.
सो then the word law would become redundant in 191.
No, my lord.
How, what would happen to that?
That's exactly what I'm saying. I'm trying to proceed step by step. So 191, I read it, my lord, but the mere fact that the expression subject to law is used does not confer any legislative power, just as that it doesn't confer any legislative power under Article 14. What it is, my lord, the power is conferred on the Supreme Court. The power is on the Supreme Court to make rules. Subject to law is a limitation on that. It's a limitation on the power that has been granted to the Supreme Court. My lord, there are two Supreme Court judgments which say that, my lord, your lordship, I've mentioned them in my, written submissions.
Mr. Bhandari, do you mean that
judgment cite kar
the
first citation?
Mr. Bhandari, do you mean that before making rules there must be some law?
Well, I'm not saying that. There may be.
So subject to law, what does it mean, subject to law?
Well, and a validly enacted law by the appropriate legislature. It could be pre-existing. It could
without any enactment, rule cannot be made.
No, rules can be made. They can
But
be
subject to law.
My lord, the rule-making power is a standalone, independent power on the Supreme Court.
But subject to law.
If there is a law, then the Parliament can make that law within the limits that I will just explain.
You said Parliament can make a law.
Parliament can, but I will just explain what in my humble understanding are the limits on that. I will explain that.
But there citations there.
Ji, my lord,
Mr. Bhandari, that is subject to constitutional law. So you borrowed this power
from the constitution and subsequently you made rules.
Yes, my lord.
This is the intent.
This is the intent. This is the intent. My lord, the citation is by Lord Khan versus Border Allotment Committee, PLD 1965, Supreme Court 623, at page 633.
For what proposition?
My lord, this expression, subject to constitution and law, was discussed in detail by Mr. Justice Kekaus in his judgment, and this was then followed in LDA versus Imrana Tivana, 2015 SCMR 1739,
दूसरा कौन सा है?
2015 SCMR
अब तो दो यार
1739.
ठीक है, ये phrase
LDA
discussed
versus
हुआ
Imrana Tivana.
है. This phrase has been discussed.
This phrase, subject to the constitution and the law.
कैसे, किस नतीजे पे पहुंचे?
And they said that it means that the power which is being made subject must be made subject to a law which is derived from some other power in the constitution.
ठीक.
See? So that's my submission, that when it says subject to the law in Article 191, in order to know what law can be made under in this context, you will have to go to other provisions of the Constitution.
रेलिवेंट पेज बता दीजिए उसका कौन सा जजमेंट है?
Well, at 65 Supreme Court 623 at 633.
633 और दूसरे वाले का?
And Imrana Tivana का है जी 2015 SCMR 1739, paras 51 to 53 at 1764, 1765.
लाहौर डेवलपमेंट अथॉरिटी 41.
इस वाली लॉ की सोर्स पर क्या गो
जी जी इसकी so this by itself I say, so you go back to 142 and there is no other provision in the body of the constitution dealing with this. So my lord, you go back to 142. 142 takes you to entry 55. So let us see whether any
Entry
part,
55 is only related to the jurisdiction part.
my lord, it will also cover practice and procedure. Just let me explain why.
It is only related to the subject to the constitution.
My lord, what?
ये जो आप अभी बता रहे हैं ना, इसमें तो सब्जेक्ट टू द
No, my
कॉन्स्टिट्यूशन
lord,
है
it's-
एंड लॉ के ऊपर नहीं है, इसके ऊपर आप जो डेफिनेशन बता रहे हैं
Kekaut साहब ने specifically subject to constitution and law भी discuss किया.
जजमेंट है ना, ये एलडीए का जो जजमेंट है इमरान टिवाना का,
नहीं सर, आप वाला देखिए,
पैराग्राफ
Kekaut साहब की.
52 the only word subject to the constitution.
No, no, sir. ये जो 65 सुप्रीम कोर्ट है, उसमें दोनों डिस्कस.
It is referring the article 142, उसमें तो शब्द लफ्ज ही शुरू में
वो
इंट्रोडक्टरी है,
तो सब्जेक्ट
तो बताया सब्जेक्ट टू कॉन्स्टिट्यूशन.
जी, बट जो 65 सुप्रीम कोर्ट है, उसमें ये उन्होंने सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ दोनों को डिस्कस किया है.
इसका जो 65 का है, कौन सा है पेज?
623 at 633.
जरा इसको पढ़ लें.
65 अगर आप देखें सर,
यस.
जी, my lord, at 633.
ये भी सब्जेक्ट टू दिस कॉन्स्टिट्यूशन ही है, लॉ नहीं है इसके अंदर.
तो है. जी, आप देख लें.
पेज आप बता रहे हैं उसमें तो नहीं मिल रहा है.
आप यहाँ से,
यू आर रेफरिंग
पढ़
पेज
देना.
633.
ये सर मैं नीचे से 11th 12th line from the bottom
पढ़िए.
at 633. The central legislature can legislate with respect to jurisdiction of courts, but the jurisdiction granted by Article 98 is subject only to this constitution and not to this constitution and the law. A reference
तो
to
ये
the
तो
various provisions of
then my lord is correct.
आगे देख लेते हैं.
अजी अच्छा.
A reference to the various provisions of the Constitution will show that whenever it uses only the word subject to this Constitution, it does not mean subject to this Constitution and the law. But whenever the intention is that a particular provision should be subject not only to the Constitution, but to a law enacted by virtue of powers granted by the Constitution says so. So, when Constitution and the law...
So what? I'm not following.
My lord, what it is
नहीं,
saying is...
वो जो आपकी don't use your own words, use the words of the
My lord,
judgment.
this is that whenever the intention is that a particular provision should be subject not only to the Constitution, but to a law enacted by virtue of powers granted by the Constitution.
It's not
begs the
enabling, it's
question.
not a power that is giving legislative competence.
Yes, that's what I'm saying, that
You have to go
then
back looking for the competence.
Yes, you have to go to the source of the power in the Constitution. And here the source of the power has to be in some other provision of the Constitution, which takes you to 142, and 142 takes you to entry
No, fair enough,
55.
but that's not coming out of this judgment.
Well, that is the only judgment on this that I
No, no,
could.
but this.
ठीक है आपने मेहनत की, that's good,
But this is how I read this
Sure,
passage.
sure, go ahead.
Then let's go to entry
And
55.
you say that that law under 191 would stand through 55,
It can only stand through 55.
only through 55.
Only through
Chale.
55. Your
But
lordship has-
एक second ठहर जाइए.
My lord.
Why not 55 read with 59?
But these are 59.
No, the 59 भी पढ़ लेना.
59 relates to matters incidental or ancillary to any matter enumerated in this part.
So it may not, देखिए जरा सा my understanding is I may be subject to correction. It may specifically be mentioned there, but it can expand. If otherwise 59 is redundant, so then ancillary matters, incidental or ancillary matters can be added on to. So every provision, every item should be read with 59.
Absolutely.
ठीक है. अच्छा,
Absolutely.
एक second. Incidentally, you mentioned privacy, and I was just going through the list. I don't come across that word in the fourth schedule. Please correct me if I'm wrong.
Well,
You said the federation can make law. You started with Article 14 and privacy. You mentioned,
My lord.
but the cursory examination of the fourth schedule does not throw up the word privacy.
it doesn't, my lord, but there
No,
are,
but you said then both the federation can make laws.
and it has.
No, it has. Can it still be unconstitutional? But in the argument, you should forget if it has. This they have also made a law, so that's neither is here nor there. But if the word is not mentioned, then your argument should have been that only the province can make the law.
Well, if
Please enlighten me.
My lord, the parliament has, for example,
ये example यही ले लेना.
legislative competence to enact laws about companies. Now, in exercise about companies.
No,
entry 31.
Bazari sir, no, please don't do
Let
this.
me-
No, don't do
Please
this.
make an argument.
You use the word, you chose the word of all the thousands of words circulating in the universe, privacy. You chose Article 14. Either you take back that argument or entrench that argument with some legal argument.
That's what I'm trying to do.
आप companies पे चले गए.
मैं कंपनी से एग्जांपल आपको समझाऊंगा जी.
Learned counsel,
कंपनी, let me
इसको
answer.
मैं जरा
Let me answer this question.
इसको formulate कर दो. आपने जिस तरह कहा कि कानून बनाने का है आर्टिकल 14 है इसमें. Regardless of and notwithstanding Article 191, say a law is validly and competently made by the legislature. What if that law is in conflict with the rules made by the Supreme Court under Article 191? How will you read subject to law? Will the rules prevail or that law?
I will come to that, but let me answer my Lord the Chief Justice's question. My Lord, in exercise of power granted by entry 31, the company law is there. Now, the company law contains elaborate provisions which deal with the question of privacy of businesses, their premises. It deals with when search and seizure can be made, documents can be.
Take the point.
So, similarly, because criminal law is on the concurrent list under entry
You
1.
make the
Article
point about
142.
privacy.
Therefore, province has also made laws which affect the concept of
Bhandari
privacy.
Sahab.
Well, privacy alone, privacy can very well be a standalone subject matter of a statute. It is a concept
यही तो
which
पूछ रहे हैं federal or provincial.
both. It
Okay,
You
ठीक
made
है.
your,
Can
you
be
made
both.
your point. If you
It
could
can-
come back to
it can
the,
be both.
you made your point.
My lord.
We've noted your
My
point.
lord,
If you
I
could come back to entry 55.
Entry 55. Let's read it, my lord. Jurisdiction, and it has two parts. The first part, and my lord, what the Honorable Chief Justice said about entry 59 is exactly my case, and I'll explain why. The first part of entry 55, jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list. So this doesn't apply to the Supreme Court.
आगे चल.
And to such extent as is expressly authorized by or under the Constitution, the enlargement of the jurisdiction of the Supreme Court and conferring thereon of supplemental powers. Once this is invoked, then, as my Lord the Chief Justice said, matters ancillary or incidental or ancillary to any matter can also be brought in. Now, what does this expression mean? Entry 55, there can only be enlargement of jurisdiction, but only where there is an express authorization by or under the Constitution.
But you're missing out the earlier words, as is expressly authorized by or under the Constitution. No, just wait a minute.
Well,
Where is 184.3 expressly authorized?
it is not.
It is. 184.3 is in the Constitution.
But there is.
समझिए ना, you're not hearing the point. देखिए, extent as is expressly authorized by or under the Constitution. 184 पार तो हमें दिया हुआ है ना आइन ने. हमें बस खुद से तो नहीं आया ना. दिया हुआ है आइन ने. ठीक है? The enlargement jurisdiction of the Supreme Court. Now the question is that 184.3 power that is already given to us. The Constitution could have not given that power to us. It is not an inherent power of the nature as under Section 9 of the Civil Procedure Code. Correct?
My lord.
It's an extraordinary power which is rarely given in any constitution in the world.
Correct, man.
Correct? So
Correct.
far we are good.
Correct.
So that power was given by the Constitution to us. Now, are they giving an forum therein, enlarging the power or taking away the power?
My lord, twofold.